Good afternoon, everybody. My name is Charles Rather, Managing Partner, Amlaw Group. Quick question today is not going to require too much time, but something that comes up a lot of times. What's the maximum stay I can stay in the U.S. on an L-1 visa? Now, the validity period of the visa depends on the country you're from. Each country has a different visa term, and it's a little confusing sometimes because sometimes they might give you a visa that's valid for 2 years, but if you're filing a new company L-1 petition, and it's a new company in the U.S., you're only going to get an approval for 1 year. So it's a little bit strange in the sense that you're going to have a visa valid for 2 years, but the approval from CIS is only good for 1 year. The short and long of it means that you really only have 1 year. The visa is valid there, so if you get a renewal on your L-1 later, you don't necessarily have to go to the embassy again and go through the process of getting the visa, but at the end of that 1 year period, you're going to have to file an extension in order to have a valid status in the U.S. So just having the visa itself, even though it says 2 years, that doesn't necessarily mean it's going to work for 2 years. You've got to look at the underlying status that you get from USCIS. But that's a technical detail. Let's get back to the main point of today's video. How long can you stay in the status? Well, it depends what type of L-1 visa you have. If you've got an L-1A, which is for executives and managers, maximum period is 7 years. So in the case of a new company, if the company's been in existence less than 1 year in the US, that means the first visa or approval they'll give you for is 1 year, and then you can renew it for 2 years each. So a total of 7. If you've got an L-1B, which I'll admit is much more rare, not as common, but still exists out there, those are for specialized workers, right? So generally an L-1B is more for technical specialists, people that have some kind of technical knowledge related maybe to operations of a particular company, maybe equipment they have, maybe software. I think we've even seen L-1Bs where they were cooks or chefs that they knew a specific type of cuisine and that couldn't be replicated and nobody else could do it. There was a case like that a couple of years ago. So the L-1B for specialized workers, that maximum period is 5 years. So meaning, again, if it's a new company, you get 1 year and then 2 extensions of 2 years each. Or in either of those cases, if your first visa or first approval of status is with an existing company in the US, that is a company that's been here more than a year, then that first approval is going to be for 3 years, not for 1 year. And then you have, the number of 2 year, subsequent 2 year extensions that are available. So in the case of an L-1A, you might get it for 3 years to start with, if it's an existing company, and then 2 2-year extensions, right? If my math is right, but I think it is. So that's a total of 7 years for an L-1A, 5 years for an L-1B. To be honest, most of our clients don't have problems with this. Why? Because I would say most of our clients who get an L-1, they eventually want to try to get permanent residency here, get a green card, and they're not going to wait till the end of that 5-year period or 7-year period, that they usually take steps before then to get a green card. And so we don't run into that issue of maximum time period in the L-1 status. Now, how do you get a green card from an L-1, whether it's L-1A or an L-1B? Well, that depends on your particular situation and your background. Many of our clients do an EB-1C if they're managers or executives. So the EB-1C is the green card counterpart of an L-1. A lot of times people will do a labor perm, so that's an EB-2 or an EB-3 where you get full-time employment. So it could be the same US company that sponsors you then for the green card. That often happens as well. Again, it's up to the US company if they want to do that. If you're working at a larger corporation, sometimes they have really stiff policies and unfriendly policies about sponsoring employees for green cards. Or you could always get employment at another company, and they might be willing to sponsor you through a labor perm or maybe some other permit or category. There's also, you can self-petition as an NIW if you're skilled enough and have enough experience as an applicant under the National Interest Waiver Program. That could be an option as well. So there's a lot of options in later to look at for a green card. It really depends on your particular case and situation. That's why we recommend a consultation, because there's nothing, even the internet can't replace a good immigration attorney. We can give you customized insights and discussions about pros and cons of any approach you might have or any approach you might consider to help you come up with the ideal option for you. This was Charles Rather. Please write to us with any questions. We'd love it if you leave a like or even subscribe to our channel. Hope to see you next time.